All right. I think we're ready to start our afternoon court calendar, and we'll do that by calling the case of the state of Wisconsin versus Cory Greasehammer. It's case 25 CM 1053. Appearances, please.
Jason Chris for the state. Attorney Stan Woodard with the public defender's office, appearing on behalf of Mr. Greasehammer, who appears in person, who I need to advise at this time, our office indicates that you're not eligible to public defense. But you're ready to go. You're always come back and check with us, all right? So don't think this is so.
Yeah, that's a good point that's made by Mr. Woodard, and the sheet that the deputy handed you, sir, describes how to contact their office to reapply if something were to change with your income or you wanted to recheck the numbers. You do have some other options. You could hire a lawyer on your own, so you could represent yourself. If you don't really think you have the money to hire a lawyer on your own, there is also a program where people can sometimes have a lawyer appointed for them at county expense with a payment plan, and that gets arranged through the clerk of court's office over at the courthouse. He's an experienced public defender, and he has a covered today, so you're in good hands then. Before I call on the lawyers, I understand there may be a victim present via Zoom who wishes to be heard regarding bail. If so, maybe we could have that person unmute their microphone. And then, ma'am, if you could give me your name or initials or however you're most comfortable identifying yourself today.
Yep. Hi, my name is Tiffany Stevens, Stevens. And then first name Tiffany, Tiffany, middle initial E as in, well, Elizabeth.
All right, very good. And is there anything that you want me to know about bail or conditions of bail in your brother's case?
Yes, Your Honor. So I have written down here, sorry, I'm going to be looking down, but I wanted to have no contact with me or my 800 block of where I live with my boyfriend. I want him to have no alcohol at all, no drugs at all, cannot drive. He does not have a license. His car, that vehicle, is not registered in his name, but it is his car, that Chevy Malibu, the black one. Again, someone else's name, but it is his car. He just had someone else register it because he doesn't have a license. So no driving, no drinking, no drugs, no contact with my job, which is Meineke, any of the locations, because I work at several of them. And then and of course, no contact where I know he can't not go to his dad's house because our parents, they're together, we're step siblings. So, but just to have like him leave if I'm, present there already. And then also to, and then if he could possibly get like a bail monitoring program with alcohol monitor to make sure he's not drinking during all of this, because he gets really violent when he drinks and he's an alcoholic. So later on we'll address that with maybe AODA or something. But anyways, for now, I'm sorry, I'm trying to make this short and sweet for you, Your Honor. And then also to have no contact with my boyfriend Victor's job, which is GE Healthcare over off Femrite Drive, right there by the parking lot, kind of by the police training center. Do you know what I'm talking about, that area?
I do.
Okay. Yep. So no contact there if possible, because he put this stuff on Facebook to have him found. And he even said in the Facebook post, like, do not engage, just call police if you see him. They're looking for him for beating up, or for hitting his girlfriend.
I see. I do have a couple of questions for you, and we won't get a whole lot into the details of what's alleged today, but
yeah.
To the extent that you've asked for him, then I have no contact with your boyfriend. I caught that his first name was Victor, but I didn't catch the last.
Sorry. Yep, Victor. So it's V-I, C as in Charlie, E as in Tango, O as in Ostrich, R as in Romeo, and then wait, what? It's Victor, Victor, sorry. And then last name, our middle initial P as in Pasquale or Paul. And then last name Flores, which is Lores.
Okay, and then my other question is that you made some comments about his driving. Is there a connection between driving and what's said to have happened in this instance?
Yeah, he took off in his car drunk driving. And the
Okay.
police couldn't find him and he didn't open his door when he went straight home. But I got the license plate number and they said it was registered into somebody else's name, but that's because he has no license. So he's driving around with no license and drunk driving.
All right, I appreciate that information. I appreciate that that you were here to share it. And then I should turn to the state for its position on that.
Okay.
This
Should I
takes
mute?
Yes, please. Thank you.
Sorry, thank you.
The state seeks a signature bond, no contact with Tiffany S., no alcohol, a ban from the 800 block of Juniper Street in South Prairie. We will join in to the ban from the mining key locations as well. Makes sense.
All right. And Mr. Woodard, any position?
We don't object to the signature bond. I think you want to be clear here. Mr. Rice Hammer. Let's say that way. Reseller. Do one business. The point of the matter is, though, Your Honor, he's advising, he's got his license. He wasn't drinking or driving or anything of that nature. Wasn't stopped for that. Regards to his driving ability. And the car's in his name. Correct. So his position is that he wants to be able to drive the car that he has. And then he will make sure, obviously, that he stays away from the family members and everyone associated with. He's happy to stay away from all of them. But he wanted to make sure if he was not driving, not driving under the influence, anything like that.
All right. And I don't see that we have a pretrial assessment for Mr. Reese Hammer. Ms. Anderson, was one completed?
No.
Okay. And a quick review of the Dane County version of CCAP suggests that he doesn't have an adult criminal record, but I don't know if either party has more information regarding it.
He has none, Your Honor.
Very nice, any information.
As far as convictions go, he has no adult criminal convictions. He's got non-regulatory.
Looks like in 2017, perhaps.
Roger.
Okay. And all right, well, let's start with the easy part because I think everybody's in agreement that a signature bond is probably the appropriate response. Here, and I agree with that.
I'm sorry, Your Honor, could I please say one thing?
Sure.
I'm so sorry. Okay, so I know I guess we can't prove that he drunk or drink and drove, but he was intoxicated when he hit me. We have multiple witnesses that say that he did drink and drive home.
All right.
Multiple
I appreciate it.
witnesses. And then
I agree.
also, the cop told me that vehicle was not registered in his name.
All right, I appreciate that information. So I'm going to order a signature bond. I'm going to order as conditions of the signature bond that he have no contact with Ms. Stevens, her place of residence, her any places of employment, to specifically include, but not be limited to, the 800 block of Juniper Street in this, inferring it's in the city of Sun Prairie. I will also order that he have no contact with Victor Flores or his place of employment to specifically include GE Healthcare. And I'll also order as a condition of the bond in this case that he not consume any alcohol. I am going to decline to order pretrial services, the drug ban, or restrictions on driving. And my reasons for that are that he lacks a prior adult criminal record. The pretrial services program is it's a finite resource. It's one for which there really are only certain available slots. I don't make this comment to underestimate or depreciate the fact that what's alleged in the complaint is a series of serious misdemeanor offenses, and Ms. Stevens is certainly reasonable to be concerned about the things that are described in the complaint. I also have to balance that against that form of monitoring being available for other individuals for whom release or not release is maybe a much closer call, or whose situations are unfortunately significantly worse than what we have here.
And then,
So-
Your Honor,
No, I'm gonna make the ruling at this point. So
No, I'm sorry. It's one last thing. I do apologize. I'm really sorry. I'm just a little anxious of obviously after everything. But I just wanted you to know too that this is not the first thing. It's one thing that got recorded. It didn't get recorded technically because his mom talked his ex-girlfriend out of it. But there is record of a fat lip that he had given her, and he beat his own girlfriend up, and she is willing to testify against that in court to like ensure that yes, he has beat other women in the past.
but certainly anybody else who's been the victim of a crime is free to report that to law enforcement. That would be reasonable. There is also going to be a condition of bond and resammer that you not consume any alcohol. Oh, I think I said that, but I was explaining the reasons why I was not ordering pretrial services and the other conditions. I'm not ordering the drug-related condition because I think we all know that's against the law anyway. So if you get caught using or possessing drugs, you could be charged with a criminal offense, and it would also be a violation of the bail, whether I say it or don't say it. And I just don't know that there's a reason to double up. I'm also not going to order the driving condition because it's really tangential to what's alleged in the complaint. It's I'm supposed to set conditions of bond that are honed or tied to the charged behavior. And while I recognize what Ms. Stevens says about what happened following this encounter, it really isn't part of the charged behavior. If, in fact, there were separate charges related to driving, that process will unfold and there can be any restrictions as a result of that. Hopefully, the no drinking condition will lessen any risks associated with operation of a vehicle as well. So there's a balance that I have to engage in here, and that's the best way I think I can do that at this point. We'll get a not guilty plea entered on Mr. Reeshammer's behalf for right now. You're going to get another court date in the next room. Ms. Stevens, I do appreciate you being here and sharing information. It's helpful. You have the right to do so. The upcoming court date.
And he also, sorry, I was gonna say he also did flee knowing the police were coming. But sorry, go ahead and finish what you're saying. I apologize.
Well, as it turns out, I think we are finished. So thank you.
Okay, no, I meant you said something. You were going to say something about me getting to the next.
No, I was just saying you do have the right to participate in any of the future court dates as well, and I'd encourage you to do that if you have things to say. That's
okay.
Right.
Thank you, Your Honor. And I'm very sorry to interrupt so many times. I'm sorry.
It's all good.
My anxiety got the best of me. Thank you.
You're all right. Bye-bye.
Bye.
Right here?
Yeah, that's one needs to be the text. That's my standard.
And sounds like we are ready for Mr. Earl. So, okay. Looks like we're ready to go. Well, we'll leave Mr. Burl back when that's possible.
And my understanding is he's not planning to participate.
All right.
Maybe I should say.
All right. Well, why don't we call the cases of Dane County and the state of Wisconsin versus Zachary Burl. Their cases 25 CM 1039 and 25 FO 785. Appearances, please.
Casey Ice appears to the state.
Attorney Stan Wood with the defender's office. Hearing on behalf of Mr. Gerald, GGRL. The advisory court that at this time, we don't know if he's eligible or not for a public defender. So he needs to contact our office in the event wishes to have a public defender. I can advise the court, though I do have a copy of the lightweight meeting that complaint on the finding the problem caused by the court. We stand you, that's court general, please, not guilty.
All right. Thank you. And Mr. Burl is appearing via Zoom. It looks like he's in a cell and seated on his bunk about as far as possible away from where the window is. My experience with these hearings is that somebody in that position would be able to observe that court is available at the window and likely would be able to hear the court proceedings as well. Perhaps the bailiff who's present at that location can just confirm if both those facts are true.
That is true and accurate.
Okay. And Mr. Burl, you're welcome to remain where you are if you wish. You're also welcome to come up to the camera closer if you wish. Either way is fine. On the non-criminal forfeiture case, we'll go ahead and release him without bail, get not guilty pleas entered on his behalf. I should probably also make a record that CCAP says that there was an attempt to conduct this hearing on Friday, and he was refusing to participate at that time, needing it to be set over to today. I was not personally present, but that's what the court record says. Mr. Dice, any position regarding bail in the criminal case?
Yes, the state would be supportive of a signature bond with the non-monetary condition of a ban from Capitol Square and the Veterans Museum.
Mr. Woodard?
Your Honor, I have no objection to the signature bond in this matter on behalf of Mr. Burl. I don't know how he feels about the non-situation here in terms of the no contact provision. I would stand mute on that, Your Honor, and the court can decide how you want to say that.
Sure. Well, I'm okay with the signature bond. I have a little reluctance about it just given the participation level, but ultimately he's not going to be released on it until he participates at least to the extent of signing the bond form. So if he does that, I think release is probably appropriate. I'll have as conditions that he did not be in the Capitol Square ban area as depicted on a map. A copy of that will be given to him upon his release. And then we'll keep a copy for the court record as well. He's also not to be at the Veterans Museum located on the Capitol Square. That's just slightly outside of the ban area, so I think we have to specifically include it in this form, and I'm doing that. Mr. Earl, I hope you're at some point make the decision to sign the papers so that you can be released, and then to comply with those rules. You'll have some other court dates. Good luck to you. Bye-bye.
All right, next will be Osama Smeari, also Gazen.
All right, we'll call the cases of the state versus Osama Smeari. Their case is 25 CF 1110 and 25 CF 1115. May we have a court appearances, please?
Nancy Dice, the first for the state.
Formal. Attorney Stan Woodard with the Public Defender's Office. Appearing on behalf of Mr. Smeari, who is eligible for a public defender. I can advise Mr. Smeari in the court. I do have copies of the complaints in this matter. In regards to the August 24, 2024, I believe that's 25 CF 1110. If I did get that correct, that's important. Stated that I now received the complaint, reading that complaint, Your Honor, as it pertains to misdemeanor matters in this complaint upon finding probable cause by the court to be stand muted. Ask court general please I'm not guilty. There are felony matters in this complaint upon the finding probable cause by the court. We did requesting a preliminary hearing. On the second complaint, which is 25 CF 1115, reading of this complaint upon and it appears that there are felony matters contained in this complaint as well as misdemeanors. On finding probable cause by the court and misdemeanor, you stand mute. Ask court general please are not guilty. In regards to the felony matters contained therein upon finding probable cause by the court, we did requesting a preliminary hearing.
And your surmise as to the case numbers and the correct orders of them was a reasonable surmise, but I think it might be backwards. The one that has the assault by prisoner charge as count one from August of 2024 is the one that has case number 1115. While the one with count one having armed burglary from April of this year is the one that has case number 1110.
Thank you, Your Honor. We're good.
You had a 50-50 shot at it. Sometimes it just doesn't work out. But Mr. Smeari is in custody on a probation or corrections related hold stemming from some convictions that were in branch 2. We'll get this case assigned to branch 2 pursuant to the local court rules. I should make a note that it looks like Mr. Smeari is at the window participating via Zoom. That's good. The court record says that that was not the case on Friday, and it got put over to today, but this is better. Mr. Dice, any position regarding bail in these cases?
Yes, 25 CF 1110. The state is asking for $7,500 cash bail or cash bond. A ban from Zaya Road entirely. A ban from East Town Mall. No dangerous weapons. I would note this isn't actually a class, the burglary, the armed burglary. The crime spree occurred while the defendant was on extended supervision for burglary. There's a substantial likelihood of incarceration, which would increase the incentives for the defendant to not appear in court. And also point out, of note was the break into Dick's Sporting Goods, which cost $80,000 in damage. and in the wall with further damage. He was ultimately contacted or naked and holding a rock and bat. Moving the officers and then was taken to jail. So in that case, I think $7,500 is appropriate. It might be moved with the probation hold anyway. And it's going to be 24 CF days. I think this is a judgment call. Clearly, he's going to likely be in custody anyway. But assault by prisoners, bodily substance. I do think some cash bail is necessary. I would say $3,000. He's got 2 counts of it with 2 different victims.
And I guess maybe what you said is consistent with what it says in the complaint if you add up the various damage estimate. But I think I heard you say the total damage was $80,000.
That's what I read in my notes for the big sporting goods was $80,000.
Okay. And Mr. Wood?
Thank you, Your Honor. Mr. Smeari, can you hear me, sir?
Yeah, I don't want this paperwork.
All right. Well, you realize there's the prosecution has recommended quite a bit of money for you to be released on for big cash.
How much did they propose?
Well, I'll have the prosecutor say it again. Go right ahead.
I asked for $7,500 on 25 CF 1110. I believe I asked for $3,000 on 24 CF case.
3,000.
$10,500 total.
All right.
$10,500 total.
Yeah, that's the total. But let me ask you: can you come up with half of that, or most of that, or what?
Not a single penny.
Okay. Well, here's a real deal, Holyfield. You've got a PO correct?
Yeah.
All right. So you're not going anywhere, no matter whether you can post bail or not. I'm going to just ask the court for a reasonable amount of cash bail. You've got that hold. You're going to go to a prelim on these cases, and you have an attorney that will be with you. That will be I'm just here today to be your attorney, but there'll be another person from our office or outside our office that will be appointed to represent you. You can always ask for bail to be reduced, but you're not going anywhere until you take care of that hold. You feel me?
I don't want to go anywhere. I'm right at home.
Okay, my friend. All right. Your Honor, as you may have heard me, I would say that you did. We're just gonna have to read a lot of judgment.
Anything else from the state?
No.
Okay. I'm going to set cash bail at $7,500 on each case. I'll adopt the conditions in case 1110 that he not be at Zaire Road and that he not be at East Town Mall. I don't know that I heard the state ask for specific conditions in the assault by prisoner related case, and I kind of understand why that would be.
That's correct. I do think that having no dangerous weapons, which would be a rule since jail anyway. So I don't think I said it.
Yeah, it doesn't sound like it's going to meaningfully make a lot of difference to Mr. Smeari or even necessarily his desires, given the differences in the bail between what I've said and what the state has requested. I'm doing that because I guess I see that the offenses are different in kind but each serious. I think there's a credible argument that the seriousness of assaulting or allegedly assaulting 2 jail deputies is at least on the par of destroying some damage at a shopping mall, though I recognize that this is an extreme set of allegations of damage to property. So I'll set the bail in those amounts. Mr. Smeari is going to be entitled to a prelim within the next 10 days, and we'll get that scheduled right away. I hope things begin to improve for you, Mr. Smeari. Take care.
Yeah, you too.
Bye-bye.
Right, have an activity.
All right. Good for the next one.
All right, thank you.
Next to be Terry Bucky.
Bucky. And on the yellow.
All right, we'll call it 8 to the state versus Terry Bucky Jr., case 25 CM 1042. Appearances, please.
Thanks, guys, for the state.
Attorney Shan Woodard from the defender's office. On behalf of the person, I advise the court that he's eligible for a public defender. I do have a copy of the complaint. I will be reading that complaint as it pertains to count 1 for the probable cause by the court. For the stand, you just scored there, please, I was not guilty. As a matter of fact, now two also of the misdemeanor matter. That did that, from a crime, from the court. We would do, as the court to, again, these are matter of football.
All right, thank you. The complaint makes reference to a corrections absconder warrant. He was booked in on a hold from corrections, though it's since been lifted. That said, because he's on supervision based on a conviction in branch 12, the local court rule said we have to get this case assigned to Judge Peacock as well. What's the state's position regarding that?
The state's asking for $250 cash, no use or possession of controlled substance or drug paraphernalia without a valid prescription. As you just noted, the defendant was absconding from extended supervision before being arrested in this matter. Given that he's already shown a willingness to abscond from extended supervision, we do think some minimal amount of cash is necessary to ensure that he cooperates with the prompt resolution of this case.
And Mr. Woodard?
Well, Your Honor, first of all, his agent has withdrew the hold. He's gonna be on supervision. Whatever happened in the past, he's definitely gonna be dealing with his agent after having had a conversation with that agent. These are misdemeanor matters, the possession matter, and then count two is a 30-day matter. We're thinking at this point that it's reasonable to request a signature bond, Your Honor. At least that's our position about being reasonable. Ask the court to do so. He's indigent and does not have wherewithal to bear on this point.
Thank you. Any response from the state? No, Your Honor. Okay. Well, I think both sides have made the appropriate arguments here. They both make a lot of sense. The state's position is reasonable in seeking some sort of cash bail when there's some issues of supervision and a warrant. The other side of this is that his agent must feel that he's able to be adequately supervised in the community or the hold wouldn't have been lifted. That factor alone isn't determinative. There certainly are times when I'll set cash bail despite an agent lifting a hold. This is a possessory drug offense. It looks like Mr. Bucky was cooperative with the police officers. It's not accompanied by an allegation about lying about his name or running or fighting or some of the things that other people unfortunately tend to do when there's absconder warrants. I have a PSA that recommends a signature bond. I think that's worth giving a shot to. I'll allow release on a signature bond. I'm just not going to set the drug related condition so as not to duplicate what is the law anyway. But Mr. Bucky, you've heard the arguments here. You don't want to put yourself in a position of having to come back.
Definitely.
All right.
I got to report to my PO as soon as I get out of here.
Okay. Well, I certainly hope it works. I hope things go well. Bye-bye. You too.
You got it.
Thanks. Do we need an interpreter? No. All right, why don't we call the case of the state versus, is it Prince Canarian? Camarian Dukes, case 25 CM 1049. Appearances, please.
Case device for the state.
Attorney Stan Woodard with the Public Defender's Office, appearing on behalf of Billy Plume, is eligible for a public defender. I do have a copy of this complaint. It's a one-page matter here, which is a disorderly conduct of criminal damage to property from finding probable cause by the court. We stand here. That's the court general. We are not guilty.
All right, thank you. The booking sheet says that there was a probation hold that has since been lifted. That stems from a conviction in Winnebago County. So, to my knowledge, the computer can just randomly assign a Dane County judge to be assigned to this new case. What's the state's position regarding that?
We're asking for a signature bond with a ban from the 1100 block of Moreland Road and no contact with Janiqua H.
The PC affidavit suggests that that name is spelled Janiqua. Mr. Woodard.
Your Honor, Ms. Dukes understands the recommendation made by the state, and we have no objection to it.
Fine, I'll order a signature bond with those conditions. We're going to get a not guilty plea entered on your behalf, Ms. Dukes. We may have talked about this and I just can't remember. Is this address in Fortinville, the best one for you? Well, what should we use?
I don't have this.
Okay, any place for mail, like a family member or a friend or something?
Not off the top of my head.
Okay. Well, we're going to be giving you your next court date before you leave. So you don't have that. Okay. But after that, court dates might come up through the mail. So it's going to be important that you try to give us some sort of an address update or check CCAP.
Okay.
Do you have a phone that gets text messages? Not so much. Okay. Well, if that changes, there's also a process for asking for text message reminders on a phone too. You're going to have to pay pretty close attention to this in order to make this work so you don't get picked up on a warrant. But I think you can do it.
I understand.
All right. Take care.
Thank you.
You're welcome. Good luck.
Thank you.
Pretty good. All right, why don't we call the case of the state versus Adam McIntyre? It's case 25 CM 1043. Appearances, please.
Case United States for the state.
Attorney Stan Wood with the Public Defender's Office. Stand on behalf of Mr. McIntyre, who appears by video from the Dane County Jail. Can advise Mr. McIntyre that at this point to not work with our office. When I say that, our office hasn't worked with you. What the matter is, we don't know whether you are going to be eligible or not. You're going to contact our office, and you can do that over the phone. They can determine your eligibility. I will represent you for today's purposes. And on your behalf, I do have a copy of the complaint. I wait reading of that complaint from finding a probable cause by the court. We would then stand mute as the court to hear pleas of not guilty.
All right. And I know we do have full audio and video connectivity with Mr. McIntyre via Zoom. Mr. Dice, any position regarding bail in this case?
The state is asking for $1,000 cash bail. No contact with Maria D. Defendant was placed on probation within Bozeman State Prison on May 2nd of this year. This incident happened 6 days later. He has a ton of missed court over his adult record, most recently December 18th of 24, May 21st of 24, October 26th of 23, September 5th of 23, August 3rd of 23, June 21st of 23, February 21st of 23, also November of 21, August of 21, May of 21. He has been convicted recently of resisting obstructing and in 2018 of felony bail jump. This was a violent attack and cash bail if necessary. I would also note that it is an Act 3 eligible offense. Nothing further.
And I don't see any sort of probation hold on the booking, though, given the timing you described, corrections may not know he's on supervision yet.
That would be my understanding. I'm also not seeing a hold yet, but that would not make sense.
Commissioner, I did search on the DOC locator prior to court. It shows the most recent case number as being on the DOC locator and that he's on supervision court, but it did show his status as active.
All right. Well, Mr. Woodard, maybe you have more information to provide.
Mr. McIntyre, can you hear me, sir? Good. How is it with your supervision right now that you're going to? That you're on, excuse me.
I mean,
Are you going to be revoked? Do you know anything about that, sir?
no, I do not.
Okay. And what is your situation right now?
Nobody's talked to me yet.
Okay. Do you have a hold on you?
Not that I know of.
You do? I'm sorry, you do have
No,
a
I
hold?
do not.
You do not have a hold.
No.
Do you have any income for bail, sir?
Huh?
Do you have any money for bail?
No, I don't.
Okay. Well, in that being the case, Your Honor, it appears that at least at this point, there's no hold on him. These are misdemeanor matters, and I would say with the
No, hold on.
non-monetary, sorry, with the non-monetary situation here, that would be enough. I think that make sure that he follows through as opposed to adding money to it. So we're asking for a signature by the.
All right. Well, I've had an opportunity to review the allegations in the complaint. They're misdemeanor charges, but they are Act 3 eligible misdemeanor charges. As I understand this, he was in front of Judge McNamara, who should also be assigned to this case. 6 days before this is alleged to have occurred, pled guilty to various offenses, including an Act 3 prior offense, and was given an imposed in state prison sentence. I don't put much weight on the lack of a hold at this point, just given that timing. It's not at all unusual that it takes some time for paperwork to catch up and people to be aware of things and all of that. I don't think that ambiguity inures to Mr. McIntyre's benefit, given the timing of all of this. Bail can certainly get modified if there's a reason to do it, but for now, the state's position is reasonable, and I'll adopt it. I'll set cash bail at $1,000 with the condition that you have no contact with Maria D. Mr. McIntyre will get your case sent on to Judge McNamara. Hopefully, it'll get scheduled soon, and you'll be able to start putting the stuff behind you. Good luck to you.
Your Honor,
Yes. Yep. Go ahead.
when I'm sorry, Your Honor. My head. I took a major head injury. I'm not doing too well. I'm sorry. Just never mind.
Okay, it's all good. I hope things do improve for you and that you recover from your injury. Take care.
I just think I needed to substitute McNamara.
Sure, that is a right that you have. And there's a time limit for doing that.
I would like it on the record that I would like it done now. I would like a different judge.
Okay, and I think the statute requires that it be done in writing, but the good news is I think you have some time to do it. I suppose I should look at the local court rule and see what the timing is to figure out if there's some way to accommodate the request or not put him in a position where he gives it up because of timing. 1 second. We decide to send it to made full request for substitution. Of course, they probably want it. Let me just look that up real quick, Mr. McIntyre.
Time, sir.
Thank you.
Thank you.
I never had saved. There's well, I experience hearing ones and getting listening.
What do we have, son?
If you can't get us, if you could save them. We won't do it. So I want you to see that. All right. So by statute, the time to request that is basically now, but we have a local court rule that extends that 20 days. I don't know what's going to happen with Mr. McIntyre, his ability to access writing materials and the like for the immediate future. I don't think I'm really supposed to honor an oral request to substitute, but maybe we could do something where, if you're willing to do this,
If you would mind writing one up I could sign, I would be more than willing to do that.
Okay. And
if they could do that for me, I'm not making any demands or anything, but they do a lot of things for me and I appreciate it.
No, this is actually a right you have, so I want to be able to facilitate it as long as everything's done according to the rules.
If they could get it as soon as possible, I'd appreciate it.
And Mr. McIntyre, did you say you're pretty confident you are going to have access to writing materials and something to do that within 20 days?
I was hoping they were going to bring me something.
Okay, I'm not sure if that's going to happen. Mr. Winter, if we give you a sheet of paper, would you be willing to write a handwritten request for substitution? And I suppose I should make sure Mr. McIntyre is good with that.
Well, since we got time with that, I can, have one drawn up. We got them. I can draw one up and then see him tomorrow.
Okay.
And have them sign it and file it on his behalf.
I think it's a great plan, and I appreciate you doing it. Yep.
I appreciate that too, sir.
No, I'm glad you brought it up, Mr. McIntyre. Good luck to you.
Mr.
Thank you, sir.
McIntyre, listen, that's going to cost you 25-cent Chinese money. Now remember that, all right?
I don't understand what he's.
It'll cost you 25 cents.
Well, I think he's teasing you, Mr. McIntyre. I think this one's going to be on the
I'm sorry. Thank you, man. Thank you.
All right.
Come on,
Come on.
Keep your head up. Keep your head up. I'll take care of him.
Yep. Thank you for doing that.
Yeah, I sure will. No problem.
Very good. Yeah. Oh, that's nice.
This one.
All right, we'll call the case of the state of Antonio Rodriguez, case 25 CF 1123. Appearances, please.
Case tonight, Supervision of the State.
Understand what is going to defendants are turned on behalf of the enterprise. I can advise Mr. Rodriguez that at this time, sir, we do not know if you're eligible for local defenders. Contact our office, we do so, and we'll do that by phone, or in person. To determine what that would be available. Okay. I will represent you for based purposes. So, all right. On his behalf, I do have a copy of the complaint. I will reading that complaint, Your Honor. It is a felony matter from the finding probable cause by the court. We do requesting a gun there and here.
All right, thank you. So Mr. Rodriguez is in custody on an ES hold. It looks like that stems from a fairly old conviction that was in branch 10. I don't know that we have a local court rule that exactly addresses that situation. Unless the clerk has different information, I'm going to suggest that we just have the case randomly assigned.
On my review, I thought I had seen that Mr. Rodriguez was on supervision until very recently from 2 or 12, but based on the DOC locator, he must still be on supervision from one of the two.
Oh, you know, and now that I look at it, the more recent case of the two, case 11 CF 419. Okay, so supervision on that case appears to have been terminated in October of 2024.
I think there's a similar message for the slightly older one as well. I'll try to confirm.
Yeah, so case 09 CF 167, which must be the case that he's still on supervision from.
Yes.
Yeah, that one was handled by Judge Flanagan. So that would be branch 12, different judge, but branch 12 is in the criminal rotation. So the local court rule would dictate that Judge Peacock be assigned to it. Thank you for the clarification on that. What's the state's position regarding bail?
The state seeks a signature bond with the additional non-monetary condition not to possess controlled substance or recognized by health description.
Mr. Whitaker?
No objection to the recommendation made by the state, Your Honor.
All right, I'm going to order a signature bond. I'm going to decline to set the specific condition of bond because using drugs is against the law anyway. So obviously they can charge you with stuff if you do. But I will double up on the conditions of bond on that. Sure.
Exactly what was found.
Well, there's a whole list of there's a whole list of things here, but we don't want to talk about that now because I don't want to have you say something out loud that then gets used against you later. I guess what I'll tell you is I think they're alleging that there was fentanyl. Should we schedule a prelim within the next 20 days, Mr. Ward?
Wait,
All right, roll good. Mr. Rodriguez, good luck. Take care. You're on. Let's bring this one.
No, I was fine. I didn't catch any wave 10 minutes.
He waited.
yes, I wait.
So we're going to do that. WDT to the next one. Minutes.
Here, no, up top.
The next line. In the
In
same
there?
box, yes. It's long. No, I branch 12.
That's me, Peter, will be our next one.
And we can back to that, yeah. Then we're going to do the status conference. No branch 12. Student type STC, and then you can take them the other important 1A. We actually don't believe in the uniform, but I don't think we keep them over here. So
I know we got some.
yeah,
So I'll get one and go up and see we have them sign it, bring it back.
right away.
well, it makes you my hero of the afternoon. So far.
That's like, you know, so make sure I do that tomorrow, because I'm off the rest of the week. I got 2 days, this thing, no, but I'll take care of it.
No.
I'm going. Don't be a devil.
It only has another 15 days.
Again, I told him I would, man, I'm gonna.
Yeah, fair enough.
Next be Anthony Peterson.
Peterson? Yeah, the yellow experts.
All right, we'll call the case of the state versus Anthony Peterson. It's case 25 CM 1050. Appearances, please.
Case tonight is the case for the state. Mr. Peterson appears in person on grounds of stand order that the public defender's on. He's eligible for a public defender. I do have a copy of the complaint. We're reading that complaint. Two counts therein are misdemeanor matters from crime from probable cause by the authorities and you that's for terms of these are not true.
All right, thank you. It appears that there are 2 open misdemeanor cases assigned to Judge White. that means by local court rule, we have to get this case assigned to that same judge. What's the state's position regarding bail?
The state seeks $300 cash bail. The defendant was out on signature bond in 2 other cases when this happened. He missed court in 24 CM 2311, November 5th to 24. He also missed court in that case on January 3rd of 25. Given that the fact that he's out on signature bond in 2 cases and a recent history of this court, cash is necessary and appropriate. Additionally, we would like a ban from the 1700 block of Thayer Road in Madison and no alcohol.
Thank you, Mr. Wood.
Thank you, Your Honor. Counsel, what was your recommendation again, please?
$300.
Good.
I really did today. You know, he goes to actually go in this one.
Your Honor, I'm asking for Mr. Peterson,
There.
has a propensity to, get in these situations with either the officers or somebody, and their misdemeanors, pending cases are two misdemeanors, and this another misdemeanor.
Was point.
Yeah, and something didn't.
Yeah, it stays the same thing.
It did.
Yeah, Mr. Peterson's been here for almost 3 years. He's from Atlanta. And let's ask family here. He's trying to find a new way, a new place, and not doing too good about it. He's a misdemeanor matter. Your Honor, he doesn't have any wherewithal both for that bail. I'm asking either for one more chance for signature bond or a very modest amount of cash.
Fine. Well, I have a PSA that recommends modest cash bail. That stands to reason to me. He's charged here with resisting police. He's released fairly recently on a separate resisting allegation. And all of that is after the first of the 3 cases where the complaint describes him having been either warned or municipally cited for similar behavior. I think it's 12 or 13 times prior to him eventually being taken into custody. Again, that was 2 arrests ago. I see the state's recommendation as being quite generous to Mr. Peterson, and I can't go below it. I'll set cash bail at $300. He's not to be in the 1700 block of Peter Road, not to consume alcohol. We'll get a not guilty plea entered on Mr. Peterson's behalf. I do hope things get better for you, so thank you. It's good.
Next up, it's gonna be Bell Spidey. This is the co-defendant who. Brian, something. There you go. Stand there and yell at Brian.
All right, well,
I forgot to write down who you sent it to. I believe one of these cases before.
indeed, thank you.
No, we did not. So this will be first time.
Well, if you go anywhere, it says range.
I'm sorry.
If you go anywhere, it says range 80. I think we're ready to go. All right, we'll call the cases of the state and county versus Donald Spivey III. Their cases 25 CF 1121 and 25 FO 611. Appearances, please.
Casey does appears for the state.
Mr. Spivey, say that again, sir. Mr. Spivey has a personal encounter with stand order in the defendant's office. And advise Mr. Mr. Spivey, that at this point, it says that you do not want a public defender. That's your right. There's no problem with that. I am a public defender. If you wish, I can represent you just for today. If you wish, you can proceed and represent yourself. What do you want to do with it? And let me take care of it. All right. So I represent Mr. Spivey for today's purposes. You can always contact our office and follow up to see the right and how long you can have a way of eligible. You can look at it. All right. I have a copy of the complaint waiting meeting that complaint, Your Honor. It appears that 2 matters contained in this complaint. Count 3 and count 4. Regardless of those matters, Your Honor, we will be strike that. We went reading. Count 3 is a felony matter from the finding probable cause by the court. We do request of preliminary hearing. And 4 is a misdemeanor matter from the finding probable cause by the court. And you, that's a question you're not doing.
All right, thank you. There were 2 complaints, the forfeiture complaint alleging possession back on April 6th. Just resulted in being released without bail and not guilty plea. It'll just tag along with the other matters. We do need to address bail and the charge of criminal conduct. Does the state have a position regarding that?
We do. We are asking for a signature bond, no contact with co-defendant Samaj Robinson, no dangerous weapons, and a curfew from 8 p.m. to 6 a.m.
What would you read? I'm sorry, I want to pick the curfew, please.
The curfew would run from 8 p.m. to 6 a.m. And I would note the defendant was found late at night, was in a vehicle that was speeding, and that's why they had a loaded handgun with an extended magazine and some THC on him. And was with another individual, the co-defendant, the co-defendant admitted to dealing drugs in there. So I do, Your Honor, I think there's some good advice and sage wisdom that nothing good happens at certain hours of the night. I do think for this young man, perhaps a curfew, well, infringing on his liberty might be what's best for him. And actually, you get sense of
All right, and Mr. Woodard. Thank you, Your Honor. I'm going to have Mr. Spivey indicate he does have a job. You still have that job?
Yes, I'm saying I'm employed as of right now. I usually don't leave work until 7:30 p.m. or after. So when the curfew is 8.
We'll go to 9.
We have no objection to the amendment by the state, Your Honor, if the court was so promised.
Well, let's do the signature bond. That part's easy. I'm also going to order that he not have contact with Samaji Robinson. He's a charged co-defendant, so I think it's reasonable to use his full name. And then I'll order that he not be armed with dangerous weapons. I'm struggling a little bit with the curfew. This is alleged to have happened at 8:40 p.m. There's probably a bunch of 4th graders that are playing on their tablets at later than that in their room. Mr. Spidey is he's 18 years old, almost working on 19 here relatively soon. Yeah, there's something to be said for the idea that as it gets later and later, sometimes the behaviors get worse and worse out there in the world. But I just see that as too big of a liberty intrusion, given the fact that he has some reasons to be out later, apart from the normal ones that citizens enjoy anyway. Yeah, I don't know that what's alleged in this complaint is really directly tied to time of night or the sort of behaviors that are more likely to occur under cover of darkness as opposed to at any time. So I appreciate the willingness to work with him on that, but I think we'll just skip it entirely on this case. Let's do it not guilty plea on any misdemeanor charges. But what about the time limits from prelim?
Where you run?
All right, real good. Good luck to you, Mr. Spivey. Take care. You're on. Yep. Yeah, that has.
Here you go.
Next to me, Ishmael Riley.
Right.
Well, sure.
Sure.
Because family, deal with it.
I haven't known that.
We'll call the case of State versus John Riley. It's case 25 CM 1051. Appearances, please.
Casey Dice, appears for the state.
Attorney Stan Woodard with the Public Defender's Office, appearing on behalf of Mr. Riley, who is a person and who is eligible for a public defender. We have a copy of the complaint, this matter, and a way reading of that complaint. For 2 counts that are misdemeanor matters, and fine is probable cause by the court of the stand used. That's for dinner, please, if not guilty.
All right, thank you. And does the state have a position on bail?
The state is supportive of a signature bond with the additional non-monetary condition of a ban from State Street map area, as well as no use or possession of controlled substance or drugs or drug paraphernalia without a valid prescription.
Your Honor, the recommendation made by the state, we have no objection.
All right, sounds like you're going to be on your way soon with the signature bond. There'll be a condition they did not be in the state Langdon ban area as depicted on the map that we're getting you a copy of here.
Okay.
There it is, and we'll keep a copy for the court file also. I'm going to skip the drug-related condition because that's just against the law anyway. So you can't have drugs or paraphernalia, or they can still charge you with stuff for that.
Specifically, illegal drug, that which is.
Well, I'm not entering any specific orders regarding it here today, but there's, in general, people are allowed to have certain types of drugs if there's a prescription for them or something. That wouldn't be a problem. But if you possess illegal drugs, they'd be, illegal, and then you could be charged with crimes for them.
Tobacco, that's illegal, right?
To my knowledge, yeah, as long as you're old enough, and I think you are. Yeah, good question. All right, Mr. Riley, take care of you. Take care. Bye-bye. And this year, bring over more than what we did.
Next would be Smaj Robinson.
That's not. Yes, they're not be staying on the honest right then.
All right, we'll call the case of the state. This is Smeari Robinson. It is case number 25 CF 1120. Appearances, please.
Casey Dice, appears for the state.
Attorney Stan Woodard with the Defender's Office. Along with Mr. Robinson, who appears in person. I can advise the court and Mr. Robinson at this time, you are not eligible for a public defender. Whatever the reason is, you can always contact them out. Maybe out. Please have them review that one more time, right? That can be done. But they are represent you. In regards to Mr. Robinson and review the complaint in this matter, it appears that there are felony matters in this complaint regarding him. In regard to the 2 counts, as I see, upon finding probable cause by the court, we be requesting a preliminary hearing.
All right, thank you. Mr. Spivey's version of the case was assigned to Judge McNamara, which means this case has to be assigned there too. Perhaps the state has a position regarding bail.
We do. We are seeking a signature bond with the conditions of no contact with the co-defendant, Mr. Spivey, no dangerous weapons, not to operate a motor vehicle, and we are asking for the same curfew from 9 p.m. to 6 a.m. The defendant is 18 years old. He was driving about 40 miles per hour over the speed limit. He was going 80, maybe 45 miles per hour over the speed limit, going 80 in a 35 mile per hour zone in a rental car. Was not rented in his name. With drugs and a loaded firearm in the car.
And so where?
One more. Thank you. Bill, you know that any drugs from this. Dane. Council, what was your recommendation for a curfew?
We don't have 9 p.m. to 6 a.m.
Your Honor, I advise the court that this young man here is still graduating from high school, is that correct? You graduated already? No, graduating. That's important, what they say, he's graduating next month, Your Honor, number 1. Number 2, he does have a job, right? So he's working. How old are you? 18 years old, Your Honor. Look, we are requesting obviously a signature bond, but with the but allowing him the opportunity to work and do what he has to do without any curfew.
Anything more from the state?
Nope.
All right, I'll release on a signature bond. I will order that he have no contact with Mr. Spivey, that he not go armed with dangerous weapons. I'll also order that he not operate a motor vehicle, but I'm going to skip the curfew. I won't set the curfew as a condition. To my knowledge, Mr. Robinson doesn't have a prior adult criminal record. The behavior described in the complaint doesn't appear directly related to time of day. The driving condition may be a somewhat closer call because he's not charged specifically with any driving offenses here. But
Can I stop you for a minute?
Yeah, that's fine.
Respect. Mr. Robinson says the car situation is his.
Not that, because my car is in the shop right now.
And you need a car, and you're gonna tell the court about why you need a car.
I need a car because I have to go to work. I don't work. It's really it depends on throughout the day. So it's like weekday or just sometimes on the weekend. Also pretty that's what I can say. I have a lot of responsibilities. A lot of them parties on that. Another one like that's 6 months old, so I'm just like man of the house and 36. I know dad at the house. My dad is diagnosed with MS, so it's a little bit harder for me to, just contaminate to my brothers and yeah, that's
How long have you had this job?
I think we're fine.
So we're asking, and you have license and everything.
Yes,
the complaint does say that he had a valid license.
So I think in light of this particular situation, Your Honor, does not have any plan B for someone to take him back and forth to work. We request that he have that opportunity to do it.
I should invite the state to provide any response.
Well, I am, sympathetic to him having some family responsibilities. Of course, he is charged with, dealing drugs, which carry with him prison sentence. It won't be very useful to his family if he's in prison. I do think the 45 miles per hour over in a rental car that was not in his name, his drugs on board, with a gun in the car, with a co-defendant, late at night. I do think it's reasonable for the community to ask him to not drive, at least for a while. Perhaps a bond motion could be filed at a later date.
Let me take a little bit closer look at the complaint.
Let's get to the say that it's a 20%. It's one of those mistakes and it would be restricted. Well, it's
But
it's pretty insane. Somebody was
some catering.
was bringing the bottom of choice. Almost big people changing that. It's like that. I'm sure it's not. I'll see. I'm not. I'm saying, well, of course, very soon. Somebody else is playing some.
That's funny, yeah, because I was looking at the skills, but there was a machine.
I just swear I don't know if you had more.
Went there. There's not honest with that.
I'm gonna be honest with you. Mr. Robinson, as well as the co-defendant, they have these jobs. You're only explaining what you guys do.
I work at Lucier Community Center, so I'm a teacher. Basically, I'm a teacher, and he's a teacher with me. And it's like 3 classes, 1, 2, 3. He's in the middle and to the right. Sometimes we have like less than 2 kids, you can bond. And it's And like 6 teachers, that's in one class. Was not, it's just me and him, 6 teachers in one class. And,
How old are the kids?
I got kindergarten. Sometimes I'm trying to move up to high school because my high school you get a little better because we pay like a little bit more. Not even for the other, just really to Nathan doesn't like I understand if that makes sense. The teacher that I had on my job right now, they don't really like connect with the kids. They just because like
Different ages.
right. Okay.
My concern, Your Honor, is if they're working, that's one thing. When they leave the job, that's it. You can't hang out. You know, the whole idea of keeping you from hanging out at this point was very recommendations by the prosecution. Then we do it. But we don't share the brother children. Yeah.
Okay, well, here's the trouble. We had the hearing already involving the other fellow, Mr. Spivey, and he was ordered not to have contact with you because we didn't necessarily have all this information at that time. So I think for the sake of consistency, I should have that same rule. I don't want to set you guys up where somebody thinks it's okay and the other person doesn't, and everybody winds up getting in trouble. So I'm going to make that condition be consistent. I'm going to order the no contact. That doesn't mean it's going to be forever. It doesn't mean it can't change. You presented some reasons for why it might make some sense to have contact under some conditions with Mr. Spivey. You and the lawyer that gets assigned to this case should talk about trying to get some relief from that or modify that condition. To me, the bigger issue is this driving business, and I'm pretty torn on it, I gotta say. I think the state's argument is persuasive about the allegation that they're allegedly driving about double the speed limit in, I don't know if I'd call it a residential area, but certainly a populated sort of area. Obviously, the complaint alleges that they were effectively riding dirty in some other ways, and that is recognized. I am also hearing some pretty pro-social good things that Mr. Robinson does that may be related to his need to be able to get around and have a license. He had a license and an ability to drive. He was compliant with the deputy in terms of pulling over. And if it wasn't for the other things that are said to have been found in the car, this would be a situation where probably he'd get a big nasty speeding ticket and there really wouldn't be restrictions on driving. I'm going to try to cut you a break on this a little bit, Mr. Robinson, and not order the no driving condition. But you don't want to put yourself in a position where you're driving in a way that draws attention to the police and you get other violations, because they could certainly ask for that condition to change. Sounds like you're something of a mentor or somebody that these smaller kids look up to. I don't want you to answer this because I don't want you to say something that the court reporter could take down and use against you later, but this complaint doesn't allege mentor kind of behavior. But you're going to get out of here and you can make decisions as you go from here that earn that trust that those kids have in you. And I hope you do. We'll get a not guilty plea entered on Mr. Robinson's behalf to any misdemeanor charges. What about the time limits for the next court date?
Wait, Driver.
All right.
Make sure you're putting for the time today. Make sure you do those things. You gotta be able to do it.
Mr. Vice made a really good observation earlier. I'm going to phrase it a little different than he did, but I think it's the same concept. You've got a family that sounds like need to. You got some kids that you're serving in that role for that need to. You don't want to put yourself in a position where you're getting in trouble or driving in a way that winds up getting you hurt. That doesn't help them at all. Take care. I hope it works out. Bye. Take care.
Oh, for me. Okay. Yes. And it says conference is on August 9th.
Yeah. All right, we'll call the case of the state versus Wesley Hockers, case 25 CF 1122. Appearances, please.
Casey guys, thanks for the stand.
Understand where the proposed finish on the thing on behalf of Mr. Hackers, who appears in person and is eligible to approach defendant I do have a copy of the complaint. I waive reading that complaint. It pertains to misdemeanor matters. Continuing this complaint upon the body probable cause by the court, we stand mute. That's for chair, please do not guilty. Now, one of the felony matters, all the line across the line by the court, to be requesting an preliminary hearing.
All right, thank you. Is the state of a position regarding ban?
Me too, Your Honor. Just 1 second.
Take your time.
Okay. First, I'll start with the non-monetary conditions. The state's asking for no alcohol with PTS monitoring. The defendant has a history of alcohol abuse. He admittedly relapsed, which triggered the events contained within the complaint. No possession of dangerous weapons. There were firearms that were in the vicinity in his apartment during this outburst. There's no allegation that they were used during this particular outburst, but the known presence of the firearm certainly contributed to the fear, both to the fear of the other apartment occupants, as well as the manner in which law enforcement had to approach the situation. And frankly, they weren't able to come in as quickly and stop it as soon due to the knowledge of weapons on scene. We're asking for no contact with two named victims, JJC and DML, as well as the general no contact with any Aspen Hill apartment staff. Additionally, we're asking for a ban for the entirety of the Aspen Hill apartment complex. That's on the 1900 block of Hawks Ridge Drive, Verona. The only exception would be when he is accompanied by law enforcement and there to secure his personal belongings. His behavior caused his neighbors to be fearful, as well as the employees who were working that day. His next door neighbor stated she was fearful of hawkers. The downstairs neighbor stated he's fearful of hawkers. The neighbor across the hallway appeared to be fearful as well. Based on the sheer number of people that were affected in the apartment building by a hawker behavior, we do request for what ultimately becomes a property ban, except for when doing a preserving a peace type situation so that he can secure his belongings. I do have a note here. The law enforcement in particular would ask us to request cash bail. So there's a DV restraining order listed on CCAT. We are aware, I do not yet see them on the CCAT, but we are aware that there are charges coming out of Brown County for terroristic threats. All very concerning behavior. I recognize that in a vacuum, this is probably not a cash bail case, but I do think, given the whole picture, we are asking for a little bit of cash.
All right, and Mr. Woodard, maybe you can tell me more.
Thank you, Judge.
Can I just add one thing? You can, but I should just before you say it, I should let you know that the court reporter takes on everything that's said. Sometimes people say things that it winds up getting used against them later, so you may not want to talk much about the facts of what are said to have happened.
I just want to wish my deepest heartfelt apology to the court and every single person that I affected that day. I had a crisis of mental health that and then unaddressed. I've been trying to be addressed for many weeks prior to this event. It just hasn't been successful because unfortunately I just haven't had me.
Okay, but I do appreciate what you're saying about that, and regardless of what happens here today, I certainly hope that things improve for you and the neighbors and things. Mr. Woodard, maybe you had additional comments before I turn back to the
Thank you, Your Honor. Nothing further. He's unable to post any cash bail. We're asking for the signature on the motion.
All right, Mr. Dice, any response or additional information?
No response.
Let me take a little bit closer look at the complaint and the public safety assessment report.
I have one free firearm, but I will surrender immediately.
Okay, thank you. The PSA suggests that he has one or more prior misdemeanor convictions, no felonies. I guess that makes sense given what he just said. Ms. Anderson, do you have any information about that prior conviction?
Yes, it was out of Shandong.
Okay.
It was operating while we were going through the alcohol controlled substance refusal, and he spent 15 days in jail for it.
Okay. Was that some time ago?
Yes,
2010.
2010.
Okay, thank you.
Yeah.
2010, I'll review it there. Better show them. So I didn't immediately notice that in CCAP, but now that you all say it, it stands out on the CCAP record. I see that. Yeah. And I'm sorry, Mr. Dice, I don't recall if you had any response or rebuttal.
I don't think I did. Yeah, I was at 15 years ago. Almost. Something like that.
Yeah, I mean, it lends some support to the idea there was a relapse here, but it's not, in and of itself, it's not any significant factor in terms of the bail. But again, I want to take another look at things.
Straightforward. And to this case, I don't know about this. All right.
We're just waiting. Now.
You're not into man.
So I'm struggling with this a little bit, and it's kind of an odd situation where I have almost a divided bail request on behalf of the state or various state actors. I think I understand both of those positions, though, and I understand why that's the case. I think there's a very credible argument to be made for cash bail, and maybe not even minor cash bail in this case. It's a pretty scary incident, probably if you're Mr. Hockers, and certainly if you're one of the other people in the building or responding law enforcement officer. There seems to be just an event of out of control behavior with threats and a variety of other things that make it concerning. It also reads exactly like a mental health crisis, like was described. It appears that the response to this was ultimately that he was taken into custody with a form of resisting and then taken to the jail rather than to a mental health facility or a hospital or something along those lines. I'm not quite sure what to make of that, but it's interesting observation. I have somebody who has a minimal prior criminal record, despite being in his upper 40s. He does not have a history of missing court. And that prior record involved a short jail sentence, probably almost the statutory minimum at the time. I think that would have been less than the statutory minimum, but we won't delve into that anymore because that's between folks in Shawano County from 15 years ago, not here. But I think this is a situation where it is reasonable to try a signature bond, but there has to be some guardrails or safeguards in place. One of those safeguards is that I'm going to have there be a referral to pretrial services. I think that there is reason for the people that live in this apartment complex to have the peace of mind of knowing that he has the GPS device and all the other monitoring equipment in place before he were to be released to the community at large. So for that reason, I'm going to direct that he cannot be released on the signature bond until it's between the hours of 8 a.m. and 3 p.m. so that he can immediately report the pretrial services, sign up, get the GPS, get the alcohol monitor. There will be conditions of bond that he have no alcohol, that he not be armed with dangerous weapons, that he not have contact with the two initial individuals identified by the state earlier on, that he have no contact with the apartment staff members except for counsel or law enforcement, and that he not be at the complex. That would not prevent him from using law enforcement to go there or to retrieve belongings. There's a little bit of unusual structure to this, but Mr. Hocker, is it probably as a practical matter? I have a comment. Well, it is what it is, but it'll sort through. But what it means probably practically is that you're going to be here tonight. But it means you probably get out in the morning, get over to pretrial services. I saw that the deputy handed you the information sheet about where to go. This is kind of taking a chance on, and I think you can succeed. I think you've succeeded for the last 15 years, doing all right. So I think you can get through this too. But it's important that you do that so that you don't get in more trouble, and so that you're not putting yourself in a bad spot or different.
I am more embarrassed
Okay.
than anything.
I don't-
I'm not going to step foot over in anywhere near the west side of Madison unless I have a deputy with me.
Right. All right. I understand.
I'm actually probably going to leave the area.
And that's fine as long as you're compliant with making the court dates and keeping up with the pretrial services. Yep. Well, again, we'll work through it. I don't want you to necessarily feel embarrassed, but take that and channel it into doing better. And I think you can do that. What about the time limits for preliminary hearing, Mr. Woodard?
Wait, Your Honor.
Okay.
And this, your other report by your deputies, you cross that out, they can go 2 days or so.
For sure, you said GPS.
Right, there's a lot. And you have that is both. Yes.
Branch
Okay.
there.
And everything I'm driving a little over line back.
Okay, that's what I.
Yeah.
It's just gonna go right over to the courthouse. Emotions, brand. Time to look that over tonight, it's just. Yes.
You can X in between those underscores. So GPS underscore X in the score.
Yes. X here.
And then the northwest. Yeah, so that's our looks like those two are the shots. I go, what?
Yep.
Schedule the boss conference. Yes. It's good, but. And then the right where they play this TCI for some reason. It's just like that sometimes.
Mr. Mallory. Remarkable campaigns that LIV.
First one, when it fills up, it's say 66 or the goal.
You want to see it.
Okay, so we can always, okay.
Hey. Martin Allen.
Yes, it did that.
All right, we'll call the case of the state of Marco Mallet. It is case number 25 CM 1046. Appearances, please.
Thank you guys, appreciate it. You understand what with the budget defendant was doing on behalf of Mr. Mallet. Mr. Mallet is eligible for public defender, but we are appointing an attorney. I do have a copy of the complaint in this matter. Where you get that complaint is one count misdemeanor or finding probable cause by the court and stand to you. That's the thing on a plea of not guilty.
All right, thank you. Mr. Mallet does have an open felony case assigned to Judge Schlipper. It's still at the preliminary hearing stage, but for trial purposes, it's assigned to that judge. We should get this case sent to the same judge. What's the state's position regarding bail?
State is supportive of it.
Any objection to that?
No objection, Your Honor.
All right, well, not too many people get a signature bond after being released on cash bail. Yeah, so that's
I was upstairs and stuff, talking with my guys and my girl on the baby lights. Man, I have a biggest cross on this. This is not a cash bill. Yeah, cash bill.
Exactly. They did you two solids. One is they're asking for the signature bond, and the other is they didn't charge you with bail jumping.
And asked me, and I think that was on the sheriff's had him with one of seeing that I was already fighting some heavy shit, that student life seeing that I was already fighting some heavy stuff that he didn't want to do until me getting like, okay, I'm actually changing, like to figure out what I really want to do about life. I'm 33 years old. I mean, I'll be 34 in a couple of months, 4 more months. I'll be 34, 3 more months. I'll be 34. So, you know,
Sounds like Thursday wasn't the greatest day, but here's the deal, if we make the right choices, you're gonna have a whole ton more Thursdays, right? So work for those, make good decisions here, we're gonna get a not guilty plea entered on your behalf, there'll be a signature bond. We'll get the case sent on to Judge Schipper's court, and then I think you're aware of it, you do have that court date on Thursday for the other case. Well, I think we have done it the 15th, but let me confirm. It's the 15th at 1:30. So we're talking this Thursday at 1:30 over at the big courtroom on the ground.
15th.
You got it.
Yes, sir.
Yep.
Thank you.
Take care now. Bye-bye.
Thank you, sir. You're welcome.
That's everyone.
Oh, we made it.
Well,